All right, we are on the record for people of the state of Michigan versus Joshua J. Wirgau, 23-21-47 FT. Today's the date and time set for sentencing. Mr. Steiger is present in person with Mr. Wirgau. Ms. Danielle Hageman Clark, on behalf of the people, is present via Zoom, as well as Ms. Rushinsky in the courtroom. Ms. Hageman Clark, I'm assuming, well, for purposes of oral argument, are you going to be doing the oral argument?
I can, if the court prefers to have it done in person, Ms. Rushinsky can do it as well, but I can be able to do it if the court prefers.
Just need to know who I'm asking questions of.
Okay, I'm all set. I can do it.
All right. Mr. Steiger, you have a copy of the pre-sentence investigation report?
You're not.
Any additions or corrections?
I reviewed the pre-sentence investigative report with my client for the sentencing page 1. There's a sentence down for us for 3 minutes. And that murder 1 was
Okay. So per prosecutorial agreement, count 4, count 5, and murder 1 were dismissed, correct?
Yes.
All right. Any objection to that inclusion, Ms. Hageman Clark?
No,
Shall be included. Anything else?
Mr. Weaver had to go through information on page 3, second full paragraph on the bottom regarding firearms that were stolen. The steel firearm was not yours. To ensure that or steel, the teal firearm.
Okay, so I'm looking on the third line, the third paragraph from the bottom, where it's got a list of 4 different firearms. Is that what you're referencing?
That is correct.
My apologies, I don't see where it says teal.
Steel G3C 9mm. Speaking of Ms. Zunsky, she stated they believe that the teal firearm.
Okay,
The one firearm reference here was actually the firearm Mr. Wirgau's in the ex-wife's mother's home, but a teal firearm is not included. Correct. Was stolen. It's a matter of clarity.
so how, I guess, to make it clear, you're just asking that we add in as well as a teal firearm?
Right. The portion of G3C is not stolen.
Okay, all right. Your position with regard to that, Ms. Hageman Clark?
if no, if you want to cross off the Force model G3C 9mm, and then if you want to add in teal firearm, I have no objection to that.
All right, that's what we'll do. Did you tracking where we're at, Mr. Weaver?
Yes, I am.
All right, anything else?
No additional.
Any other additions or corrections from your standpoint, Ms. Hageman Clark?
No,
We have an issue with sentence.
Okay,
Regarding controlling conviction of involuntary manslaughter. In this bill, I direct the court's attention to OB3.
okay,
OB3 is score 50 points. OB3 requires to score 50 points that there must be a death result of the operation of the bill.
that would appear to be so.
And this is all in futility. It's not going to matter.
I understand it was a sentencing agreement, but Ms. Hageman Clark, in looking at OB3, physical injury to the victim, under the statute 777.22, it does indicate within the offense variables that was from the commission of a crime and the offense or attempted offense involved the operation of a vehicle, vessel, ORV, snowmobile, aircraft, or locomotive under the under the circumstances defined by law. Would you agree that OB50 should not apply?
I would agree that that is correct. I do think that 25 points is appropriate. There is a case directly on point, although I did not pull it.
Yeah, I was actually,
Here.
yeah, I was going to actually indicate that I believe OB 25 would apply. Or, I'm sorry,
Yeah.
OB 3, 25 points, yes.
I would agree with that.
Mr. Steiger?
I would not agree with that.
And what would your, just because it's not life-threatening or permanent incapacitating? I think if it resulted in the death of the individual, that likely there was life-threatening or permanent incapacitating injury. So I am going to score that at 25 points for OB3. Takes the OB level to 125.
One more challenge on that.
Go ahead.
In reference to Ms. Hill, requires some sort of and that means not taking for moving the no testimony that force to go to park. Maybe under the circumstances that but it's not close. And again, it's all.
I understand. I understand that you still have to argue the guidelines. Any response, Ms. Hageman-Clark?
Yeah, if you look at the abuse of indicates a victim was transported to another place of greater danger or to a situation of greater danger or was held captive beyond the time necessary to commit the offense. There is no language there that indicates force or being forced to go to a different location is required. And so I do think 15.
The court finds that the position of the prosecutor is warranted in that it doesn't say that there has to be any threat, just that the person was moved or escorted to another place of greater danger. Obviously, in this situation, it was a place of greater danger. It was a place of isolation. And so I do find that OB8 should be scored at 15 points.
Regardless, it should be the same 58.71 as was placed on the record at the time. We understood that the agreement that Mr. Wirgau agreed to, the sentence agreement was 15 years and that would exceed the guidelines.
Understood. Is anything else for allocution?
Regarding usually only the state of judge make statements.
Okay, Mr. Wirgau, go ahead.
Apologize to the family, the victims, for my role in what I did. And I own up to everything I did. And I'm gonna go serve like that.
Okay. All right, you can have a seat for a second. Ms. Hageman-Clark, as to allocution.
Right, I believe that there are people in court today who would like to speak on behalf of the families.
Okay. And with regard to those, Ms. Mushinsky, do you have individuals that you want to call for?
We do, Your Honor. If I could first to read the victim statement written by Mr. Dwayne Bill, father of Springville, Mr. Netta, she read that.
Okay, go ahead.
As I'm sitting here writing this letter, all I can think about is Brindle that had her life shortened for no apparent reason in this senseless act. As I sat through Joshua's testimony, it became apparently clear he had no remorse for his part of what happened to my daughter. The simple fact is, you buried my daughter's body in your backyard as if she were a piece of trash. Who knows if we would ever found her if certain ticks didn't come in. The saddest part is, Bryn will never get to experience life. She'll never get to have kids, or a family, or maybe grandkids, or look after her brother, Kane Bill, who has autism. She'll never know failure. Bryn was so full of life, and she didn't deserve this outcome. I'm asking the court to give the max sentence of the 30 years because, as far as I'm concerned, Josh Wirgau got his break for testifying against Brad Sharpney. Josh should be serving life in prison too. Sincerely, Dwayne Bill, Bryn's father, #justice.
Okay,
We have that.
come on up to the podium, man. If you could just state your name first.
Madeline Brzezinski. I have never met Josh. I had taken Ambien as a youth and made a pact with my family. I am typically a forgiving person and truly believe that even good people make mistakes, and sometimes decisions are made in haste without consequences. Despite the consequences. I really have tried to be understanding and try not to judge and listen to all the facts. And because I don't know the circumstances that led to that decision. With that said, besides the small town gossip, speculation, and everything we had to endure throughout this, we don't feel forgiving in this matter. I believe Josh should be just as responsible. I believe he could have made a difference in the outcome, and most likely was begged to do so. Instead, he chose his own self-preservation and selfishness. He left 3 kids, or 3 children without a mother, and with the oldest one having to share her memories with the young ones. And they'll never hear her laughter, which she laughed a lot. She was kind and had a pair of hugs and kisses. She gave the kids all the time. She loved her kids. But all the kids have left is a few slight memories, and they just can't get that back. And we'd like to see Max sentencing as well. So,
Is there anyone else, Ms. Mushinski?
no, Judge, that would be all. Thank you.
I did note that I received a victim impact statement from Rexanne as well today. I don't know if Mr. Steiger, did you get a copy of that as well? Or did review that prior to sentencing today? All of the individuals that spoke, as well as the victim impact statement that I received, as well as the information attached to the report, indicate one thing, and that is, Mr. Wirgau, that they believe that you should be receiving a max sentence as well. Today, I would have hoped to, I know that you indicated that you were sorry, but I think what everybody is left here wondering is why. You said you were sorry, but no, you didn't provide any information as to how or why this happened. And I think there's a lot of individuals that don't have that forgiveness in their hearts right now because you haven't provided that. You haven't told them why. You haven't told them what was in your mind and why you did what you did. They've also asked for the max sentence, and because you haven't done that, I can absolutely understand that. And frankly, even if you had done that, I don't think that that would necessarily change their opinion because you've taken something that was precious from them. And now you're going to end up with something precious that's being taken from you. It's an agreement. It's an agreement that this court can't modify. That agreement between the prosecution and the defense was for 15 to 30 years. For me to modify that, I'd have to set aside your plea and basically undo everything that's been done today, which I can't do without impacting so many things on down the line. And frankly, I don't think you can pull that rabbit back out of that hat. So I am going to follow the sentence agreement despite what the family has said. Despite the fact that while you apologized, you didn't provide any background or information to anybody as to why it is that this happened. Court is going to sentence you as to count 1 for dead bodies, disinterment, mutilation, for a period of 10 years to 20 years with credit for 149 days. Crime victim assessment of $130, court costs of $700, attorney fees of $350, and state costs of $68. As to count 2, accessory after the fact, 5 years to 10 years with credit for 149 days, $68 state cost. And as to the charge that is the principal charge, involuntary manslaughter, the amended charge that was added by the people and you agreed to plead to, 15 years to 30 years with credit for 149 days with $68 state cost. You have the right to file an application for leave to appeal with the Michigan Court of Appeals. If you cannot afford an attorney, one will be appointed for you at public expense. The request would have to be filled out and returned within 42 days of today's date. Thank you. Off the record. All set. Deputy or Sergeant Ritter, how do you, and Sergeant Jones, how do you want the individuals in the courtroom to file out?
Give us some more game out here.
Okay. So if everybody could just stay seated for a moment and then we'll go out together. Thank you. The individuals that are Sergeant Ritter. When you're ready and you want to let out the individuals on this side of the courtroom, feel free. So we'll just go with this side of the courtroom first so that we don't have both sides going at the same time. Make sure please. I know you're more than welcome to. I'm just trying to keep everything separate. Okay.